we can move on to the second point, that is private enforcement. If you
So
could give
this,
background
yeah.
on that.
So just to before I start with this, I think each and every point which I have mentioned in itself should take an hour, but I will try to encapsulate it as to the best extent that I can is possible. Now, generally under the Act, what happens is if you are found in violation of a cartel behavior or any entering into any anti-competitive agreement, or you've engaged in an abuse of dominance, you are levied a penalty. The penalty obviously will be contested. Obviously, it will go to the Supreme Court. The worst, finally, whatever the penalty is imposed by the court of the land goes to the Consolidated Fund of India. It doesn't go to the person who is informing. Thereafter, the informant can file a case for damages, which is private enforcement,
Yeah.
before National Company Law Appellate Tribunal, not before the CCI, but the Appellate Forum. Now, there are certain cases which are going on as far as private enforcement are concerned. Excel Corp being one of them, and Shakes being another one more of them. So there are few cases which are going on. Fundamentally, I believe that the private enforcement, if it takes off, will give much more teeth to competition law as a subject, as a market regulator. Why I say so is because if you have incurred a damage, you can actually file a case before National Company Law Appellate Tribunal. And based on the law as it exists in EU, etc., you not only get damages for actual losses, but loss in profits also, which is opportunistic loss. So, for what I mean to say is, because of your conduct, I have suffered, say, rupees 100 over the last 3 years. So, I'll not only claim that rupees 100, I'll also claim that if I had got rupees 100, I would have, say, set up more factories. I would have supplied more products. So that's an opportunity loss. Obviously, how to calculate, how to come up with a calculation is all an economic kind of a behavior. Economic evidences will be adduced. But you can claim that also. The law is silent. It says damages. But as far as the EU law is concerned, or the EU practice is concerned, you can claim both actual losses and loss in profits. Now, the difficulty which arises is you can come up with the figures in a abuse of dominance case, for example. I would say slightly on the easier side.
Yeah.
But in a cartel case, for example, in a cartel case, you have found that there may be five participants who, under aegis of a trade association, had engaged in a cartel behavior, and materials were given to you at a markup price.
Right.
Now, how do I determine how much loss I have incurred because of an action of a single enterprise or a trade association?
Yeah.
So that is one of the points. How do you apportion the loss? How do I apportion that out of 100 rupees loss, I apportion rupees 3 to company A, 4 to company B, and 3 to company C? How much? Then the question is, how much should I apportion to the trade association? Because at the end of the day, the trade association is just an association of enterprises.
Yes.
How much do I apportion to the trade association that you had meetings under the trade association? The other issue is, which is now being debated in the Excel Corp maintainability case. It will go. I'm sure it will go in appeal. I was having a discussion with one of our peers. While a competition law action is an action in rem, a
Yes.
compensation action, in my opinion, is an action in personam, because I'm personally asking that you have, because of your conduct, I've incurred so many damages. So I need to show individual applications showing each loss from everybody individually on an individual basis. Can I then file a combined application against all of them, or should I file individual applications? So, flip side, I can file class actions, but
Yes.
in a class action, the respondent remains the same.
Yeah.
That all these 10 people have suffered losses because of an action of you. So, class action, it is, say, company A to company Z versus company AA, for example. But can I file? So that's a question of law. That can I file as as a company A compensation application against company B, C, D as a common respondent? because my claim against each of them would be completely different. So these are the kind of issues which will come up, but these are secondary issues in my opinion. As a fundamental point, I believe that private enforcement, I hope and I sincerely pray that it actually picks up, because that will give a lot of teeth to the competition authority, because not only you will have to pay penalty,
Yeah.
you would also have to pay damages to individual companies. So just to take an example forward, say in a cartel case, I have filed for leniency.
Yes.
Despite engaging in cartel behavior, I may have been the ringleader. Basically, for the easy understanding of everybody, ringleader is a person who is actually orchestrating the entire cartel. So I'm the main hero of that cartel, or the main villain, as you see it. I'm orchestrating the entire cartel, and then I go and say leniency, please give me 100% immunity, fine others. So while that leniency applicant may get 100% immunity, but as a consumer of that cartel, I can take him under a private action before National Company Law Appellate Tribunal. So if it picks up as a strategy before you file a leniency application, you need to keep that in mind, that a private action can be initiated against you. And a private action always is much more than the penalty, because you're, again, like I said, it's actual losses plus loss in profits. In MCX case, MCX has filed a compensation of 800 crores, whereas the penalty is only 50 crores. So I do not know whether 800 crores will be awarded. So obviously it will be heavily contested. But say for the sake of argument, it is actually awarded and upheld by the Supreme Court. Consider the kind of teeth that a competition law gets.
Yeah.
So this I'm genuinely seeing, because there are certain live cases going on before the National Company Law Appellate Tribunal. There will be a lot of jurisprudence which will be laid down on this point.
Absolutely. And we said that private enforcement is not something that has been happening in the past.
Yes.
But sir, what is the reason for that? Like, why is it that despite there being a provision for it in the Act, why haven't parties gone for private enforcement as much as we would like to see?
Because the law is designed in such a manner, because you cannot file a compensation application before the CCI. You have to file a compensation application before a National Company Law Appellate Tribunal.
Right.
Now, the consequence of that is you have to wait for a CCI order, which takes its own sweet time. Once the CCI order is passed, obviously you can only file compensation if you have found the opposite party guilty of Section 3 or 4. Those opposite parties definitely will appeal.
Yeah.
So National Company Law Appellate Tribunal will say, let me decide on the merits of the appeal, and then decide whether compensation should be granted. So, for example, CCI finds a party A guilty on 5 counts. The compensation application I will file will be on basis of harm which I have been caused because of those 5 grounds.
Absolutely.
NCLAT says no, not 5 grounds, only 3 grounds. And
Yeah.
then again the party will appeal.
Yeah.
So there will be appeals and cross appeals. So unless the main merit of the matter has been settled by the Supreme Court, while you can file, it will not be heard. Or the Supreme Court or the NCLAT has to come out with a via media to ensure both can run parallelly. So that is a novel approach that a regulator or a quasi-judicial body in this matter, that is a appellate tribunal and the Supreme Court, has to devise, which I'm sure they will devise in course of time. But that is a long and short answer, that's why it's taking so much time. But now, since it has started now, I feel that this will be a huge trend going forward.
Absolutely.